Good evening. May I have your attention, please? Good evening and welcome. Thank you for coming. You've got a lot to do. Some of you are headed out to other places this evening, so we'll get right into it. My name's Tim Teddy, Community Development Director for the City of Columbia. This is another of our several forums on the comprehensive update of the City Development Code. That means primarily the zoning ordinance, but also the subdivision regulations ordinance of the city. 2 chapters out of the city code, both that relate to development and land use. And we have hired Clarion Associates to be our lead consultant on that effort. They are with us here to deliver really the first third of a new code. It's entitled Zone Districts and Permitted Uses, or Module 1, and they will explain their methodology. It's a 3-part effort, so what you have available for review is not a complete code from start to finish. It's really approximately a third of the content, and that's a tried and true method that they've employed in other communities. And you can expect further work on development standards or how individual sites are to be handled, to be delivered later on, and we'll explain the schedule for that. And then finally, the third module is going to deal with procedures and enforcement of the ordinance. So I'd like to introduce Don Elliott with Clarion Associates. With him is Kristen Sazowski. We've also hired, or they have hired Farrell Madden as a sub-consultant, and they're going to do some work on the downtown, preparing form-based standards for downtown that would be integrated into this code. And most of their work, quite honestly, is going to be handled in Module 2, so you'll be seeing them in October, but they're not with us on this visit. So Don, I'll let you take it away with the presentation. We're going to go till about 8 o'clock tonight, just so you know. Won't kick anybody out at 8, though, if you want to stay and ask Don and Kristen any questions. But thanks again for being with us. Don?
Yes, thank you. Thank you. I was asked to use the mic, so I will endeavor to stand still and use the mic, which is the standing still part is the hard part. So, Tim gave you a lot of the background. Thank you for having us again. I see a lot of familiar faces. I'm glad that people are tracking this all the way through the process. It can't be a short process. Tim used the words tried and true, and this is a way that we have been successful working these issues through in many cities. Let's just go through the presentation. I know that some of you will have questions. The point of this is to give you an overview for those few new faces here as to what the process is and where we are in the process. Secondly, walk you through the major parts of this first 1/3, and then talk about next steps and where we go from here. So, just so you, to repeat what Tim said, the major goal is to integrate Chapter 29 and 25, zoning and subdivision, so that, and update them so that they reflect the future of the city called for in Columbia Imagine. That's the main goal, bring it into alignment with the comprehensive plan. But there are several other goals in there. One of them is to streamline administration so that the government can operate as efficiently as possible. And just in English speak, to not require hearings as often as possible before City Council and the Planning Commission, but to instead build the quality standards in so that you get that level of protection without a hearing. User-friendly is highly important in most cities, that citizens of average intelligence can tell what they can do with their property and what their neighbors can do. And then the downtown, and I'll just say what Tim said before. We know that downtown is the hot topic. We know that it's debated regularly. When we set up the schedule, we said we can't do it first. It's not wise to do it first. We will do it in the course of working through this process, and you will not have to wait very long because we'll be here in October to talk about it. There is no draft of the C2 replacement in my pocket or in Farrell Madden's pocket. It doesn't exist. I'm not hiding it from you. It doesn't exist. It will exist by October. Here's where we are in the process. There was a 6-step process. We started with interviews. We then put out an outline, which has been posted on the website, our kind of roadmap. Then we go through 3 and 4. This is the heart of our work, to put out a staff draft of the first third, correct it for mistakes. I don't know if I'm proud or not. I guess I'm proud to tell you your staff is doing their job, because when we put out the staff draft, they came back with lots of comments about what we could do better. So they are watching carefully what we did, and we made a lot of changes. But now you've got the public draft. Public draft means it's good enough for the public to review and offer their comments. We expect there to be hundreds of comments on this because there are many judgment calls involved as to what really is simpler, what really would implement Columbia Imagine. This is not a final draft. I want to be very clear. This is not proposed for introduction to the Planning Commission and adoption by City Council. This is rolling it, doing our work, putting it out, editing it once, putting it out in hopes that you can help us improve it. And when those changes are made in the course of time, in the spring of next year, summer of next year, then it will be ready to go to Planning Commission. Public means good enough for you to begin to comment on, not good enough to be adopted. Then, after we do that with the modules, I'll tell you what they are coming up, we will test it on some prototypical developments. This is something we want to have happen in Columbia. Does the new code make it easy to do? This is something we don't want to see more of. Does the new code correctly reflect the goals of Columbia Imagine, that will be harder to do or impossible to do? That's the testing part, and then we help do the testimony and run the hearings to get it adopted, or to at least go through the adoption process. Briefly speaking, I'm sorry this is hard to read, but I guess you have other screens up there. The left column is the current layout of your current zoning ordinance. The middle column is the current structure of your subdivision regulations. They are both long. They are both non-intuitive. Our goal, as outlined in the annotated outline, is to say, we think this really falls into just 5 categories. General boilerplate legal provisions, a list of zone districts that exist in the City of Columbia, a list of permitted uses, a chapter that says, what can you do by right or with permission in every zone district in the city? A chapter number 4 on how do you lay the site out? What is the form? We're not talking about what you can do, but what can you build? Do you need open space? Do you need landscaping? How much parking? What about the lighting? What about the stormwater? We're talking about how do you lay out the site? And 5 is, do you need somebody's permission to go ahead with this? If so, who will decide? How will they decide? How do you appeal it? And how is this code enforced? So 5 is the procedures part of it. So that's the 5 chapters. The left-hand column here shows you those 5 chapters with different colors, and I just want to reiterate what Tim said. Today we were talking about the 2 chapters in blue, 2/5 of this ordinance, that are the backbone of zoning, the skeleton upon which everything else turns. What are the zone districts, and what can you do in each of those zone districts? In October, we'll bring forward the next how do you lay out the site, including the downtown form standards, and in January, we'll bring forward the draft of procedures. So let's talk about the highlights. As I said, there are 2 chapters. Actually, I'm going to skip this over because we go into more detail. Let's start with Chapter 2. What are the zone districts in the City of Columbia? I'm sorry this overlaps. Each projector seems to be slightly different. You currently have 25 zone districts in the City of Columbia. That is not too many, actually, for a city this size. But part of our job in updating the code is to say, are you micromanaging this? Are you dividing things into almost similar districts that don't need to be separate districts and could be consolidated because they really are the same thing with minor differences? Or the market has gone in a direction that says you don't need to have 2 different flavors of this type of land. So we have recommended consolidating it. You are all aware that another big part of this is to replace the C2 downtown district with a MDT. Get used to saying that, MDT, mixed use downtown. That's another big one. Your 4 planned districts, you now have 4 kinds. PUD is basically residential planning, OP is office planned, C is commercial planned, and MP is manufacturing planned. Those are basically negotiated zone districts. I know many of you in the audience have heard me say this before. I'm going to say it again. You use these way too much for most cities. Negotiated districts are a way of micromanaging this, but most cities find it a very labor-intensive way of managing it. They often wind up reflecting what people thought were pretty on August 5th, 2014, But by 10 years from now, they don't look so pretty, and you wish you hadn't tied it down quite so tightly because cities change. And these planned districts are great at locking in an image. They're not great at living over time. And when they have to be amended, you go back to council again. So we have said, and I will stand by my statement, a healthy city uses these much less often than you do and doesn't need 4 flavors of it. You need 1 flavor of it, and then you negotiate within a fairly simple set of standards when you need to use it. Let's talk about residential. We met with builders today and realtors, and we met with the downtown yesterday. We met with some neighborhoods. This is something you may have strong feelings about. In the left-hand column is your current districts. There are 6 residential districts. In the right-hand column are 4, and the big changes are we are recommending that R3 and R4 be merged into 1 district. There is very little R4 land in the city, but we are recommending that. Conceptually, I just need to be very straight with you. This is an attempt to split the baby. Columbia Imagined says, in order to reduce sprawl and help contain and manage the growth in the city, we generally think the mixed-use neighborhoods, the multifamily neighborhoods need to densify. But right now, you have large parts around downtown that are zoned for multifamily that also have many, many single-family and duplex homes. Those neighborhoods are really worried about apartment houses next door and apartment houses nearby. Our approach is to say they can be 1 district. We can use fundamentally the R4 standards, and then we will have provisions that require that intensity and height to taper down so that it is essentially a single-family house height when it is near a single-family or a duplex district. So we have a yin and a yang. Are you increasing base density? Yes. Are you trying to draft standards that will require those to taper down and be better neighbors to the single and 2-family neighborhoods that are surrounding them? Yes. That is the approach we're trying to take here. I know that some people are quite nervous about that, and we expect to get some real comments on that. The manufactured housing did not change, and planned district, I just explained, we're rolling it into 1. Now, cottage development. Columbia Imagined talks about allowing a wider range of housing in order to get more housing diversity and to allow the market to create new types of housing product. Most cities of your size want that to happen. They want there to be more than just single-family homes, duplexes, and apartment buildings. They want there to be things like this. And a cottage development is one in which a limited amount of land, not 1 lot, but a limited area of land, you say, look, go ahead and build more houses than you could otherwise as long as they are small houses. By small, it could be 1,000 square feet, could be 800 square feet. They're smaller houses with less impact. They're going to be smaller households because they're smaller houses, and that means less traffic. And this is something that has, to be honest, originated on the coasts, and it's making its way to the middle of the country. But many cities are looking at this, and we have proposed that. Now, we could have created a separate district and said, okay, let's create a cottage district. But that means each time you do it, you're going to go through a hearing. Instead of doing that, we have recommended, I'll show you in a minute, that this be something you can be able to do under certain conditions in the R2 areas. You've already got single family, you've already got duplexes by right in those areas. This could be a 3rd variation of housing. Sure.
We have certain neighborhoods that have overlays and...
Right. This is intended to be a general rule, but the overlays neighborhood overlays trump these rules. If you have an overlay in your area and it said no cottages, then there would be no... If it doesn't say cottages, the overlays trump these rules. Understand. Well, if I want to make this available in Columbia where you want to make it available. Right now, it's a general R2. If the intention is that this worries the neighborhoods with overlays, then we probably need to revise the overlays to clarify that they're not intended to be allowed there, or they are. Well, let's talk about that. When we bring this forward, we have a code here. And I'd be happy to be corrected by anybody, but the neighbors around East Campus, North Central, and Benton Stevens are quite, I think all 3 of them feel like their overlays could use some updating. we have not closed that door. We've said if they want to bring forward improvements, they can be considered as part of this process. So if you want that not to happen, somebody needs to tell me, because right now, the neighborhood's reaction to our basic rules turns on how their overlays are going to fare in relation to those rules. And so it's not, I think it's hard for them to react if you say, well, I'm only talking about the base, but you can't talk about your overlay. So we've said that door is open to talk about. I see some more nervousness out there, but let's go on and go through here. This is a big change if you're especially a builder, but it's intended also to make the neighborhoods more comfortable. In addition to what I just said about intensity tapering down, this is an example of how, in the case where you're building multifamily housing, the draft that has been posted on the city's website says when you do multifamily housing, you need to address the design of that multifamily housing through these kinds of standards. I think the builders are quite nervous. I fully expect to get a letter from them saying, I don't like it. Neighbors tend to like the fact that the buildings would be articulated and not quite so massive and blocky, and that they would relate better to the street. This will be a matter of getting comments back on this until people are satisfied that this would help multifamily to be a better neighbor to what is happening near or across the street from it. And where it ends up is where it winds up. But there is a draft on the table. I've said this at past meetings. Our experience is, I would rather put a draft on the table and have you tell me I'm wrong than sit around talking endlessly about whether or not we need design standards for multifamily. We would never get anywhere. It's better to put it out there and say, right, wrong, or indifferent, tell us. Mixed use. You now have 3 office districts and 4 commercial districts and 1 industrial district, which is really a mixed use because they all allow residential under the current code. Things that allow residential and non-residential are mixed-use districts, and we call them that. So there's a new category called mixed-use districts. Your 2 office districts, we think, can be consolidated into 1. The differences are not very great. The commercial districts, what you're used to as C1, small scale, C2, kind of corridor shopping center, C3, corridor shopping center, and C2 downtown, are being reordered so that it goes from small, medium, downtown. And they're being given names, mixed-use neighborhood, mixed-use corridor, mixed-use downtown. That's a renaming. There were 3, there still are 3. They're being called by different names. But you have a small, medium, and downtown business mixed-use district. As I said, the business park district, increasingly we find residential can be mixed in. You already allow it, so this is just being renamed as a mixed-use district because it can happen. I'm going to show you, just walk you briefly through this. In mixed-use neighborhood, what you now know as C1, it's supposed to be a small-scale neighborhood serving area. Through historical reasons, there are some areas where larger shopping centers have been zoned C1, but they really probably should be C3, the way you've got it. But right now, it's supposed to be small scale, and we have, I'm going to put this over here. The 2 right-hand images are examples of the drawings and the tables we put in every zone district. So in this case, I'm showing you the drawing for mixed-use neighborhood scale and the drawing and the table. The table, middle column, this is a shorthand to help investors and neighborhoods know how tall can it be, how far back from the property line, what's allowed, how much open space is required. It's not the whole story. The footer, which you can't read, says this is a summary. You need to go read chapter 29.4.1 to get the details, but this gives you a snapshot. The right-hand column is circled in red because we are recommending that there be an alternative set of standards within this district which a property owner could request that would allow them to do more walkable neighborhood scale shopping areas with less parking and the buildings closer to the street, so that right now it's kind of an auto-oriented district. A lot of them are auto-oriented. Frankly, it doesn't fit well with the walkable ones that are in the city. And Columbia Imagine talks about encouraging small-scale retail and convenience retail to be near homes. So our recommendation, instead of creating a new district called mixed-use neighborhood walkable, is to allow 2 sets of alternative standards in which a property owner could request the use of the right-hand column as an alternative. Until they do, nothing changes. But when they do. Now, I'm going to get a question. How would that happen, Don? Is it the Planning Commission? Is it staff? Is it City Council? We haven't decided that yet. I'm showing you that the direction we're going down is to say we want to create an alternative which is more walkable, and we will address the issue of how you get those standards, how you request. Okay, Don says, I want those standards. Who has to approve them? That is a Module 3 process question, and I don't have an answer for you yet. But you can envision that there is a district here with 2 alternative sets of standards to address that goal of Columbia Imagined. MC is your corridor, which you now know as C3. The one thing you should know about this is that we are carrying, at this point, no one has asked us to increase or decrease the densities in that area, so your general shopping center zone. We haven't gone through all of the dimensional discussions. We've just shown you what's there now. However, we are going to recommend that higher buildings and more dense buildings can be built within this district near arterial intersections, because that is where we predict you will have evolving bus service over time. The question is, how do you encourage the bus service to grow? Answer, you have to fund it, but you have to put people near where the bus service is. The more people you put near them, the more people ride the bus. Where will that be? I don't know. We can look at your current map, but the job of the bus system is to evolve that over time. Where would you bet they would be? They're going to be on the big streets, and they're going to intersect at the big intersections, because that's where bus traffic annoys people the least. And so that's where it is likely to grow. And by allowing more density near those intersections, we think we're putting people in the place where they can help grow that bus system. And people who want to use transit will have more opportunities to live. So that's the goal there, is to say the rules on density are X, but if you're within this many feet of an arterial intersection, you can build bigger than that and provide less parking if you're orienting your building to the street and to street traffic and street use. Finally, downtown, I'm not going to get too far into that to say that we'll talk about uses tonight, but the form standards will be here in October. Here's our comment. We'll talk about the use table tonight. We'll talk about the graphics in the future. Last 2 slides on this to show the consolidations. Here, after we talk about residential districts and then mixed-use districts, every city has a category that doesn't allow residential at all because they're worried about how it works. And so that's, in this case, called special purpose districts. You now have 3 industrial districts plus a planned district plus a business park district. We think that's more than you need. And so we are suggesting that MC, M1, and MU is an underground district, which we've never seen before, be consolidated into a general industrial district. It's not heavy industrial. You don't have Boeing. You don't have GM. It is a general industrial district that would allow light to medium industry, and that would be transformed here. The agricultural district carries over. Your current code does not have an open space district that you would use to zone parks or trails or greenways, or a property owner with a big development who comes in and says, I'm making this public open space. He may want to keep it in private, but you may want a zone district that says, okay, then it's zoned O, and to change it away from open space, you have to go to council to get it rezoned. Most codes have an open space zone. Yours does not, so we're recommending you get it. And then planned development is the consolidation of the 4 planned development districts. I want to be clear that those districts, no matter which flavor they were, that were adopted before this zone district, this UDO gets adopted, don't change. The conditions attached to every CP, MP, OP that have adopted so far are not in the code. They're in the planning office, the community development office, because they were negotiated, and they would remain. No one is trying to rewrite the conditions that have been attached to anything that has been negotiated in the past, so those would stay the same. I've talked about these things. I do want to talk a little bit, we've talked about PD and consolidations. Last slide on the consolidations is the overlays. Overlays are a second layer of zoning, and these are changing very little. You have one, which is where the Benton-Stevens and East Campus neighborhood protection overlays live. They are variations of UC, urban conservation. I think the current draft is better than what you have now because it names them and it shows the map of their boundaries. So a reader would know, okay, am I in this overlay district or not? You don't have to put that in the code. You could put it's in a zoning map somewhere. But in general, we find this is a big way to make codes user-friendly, is to put the map in there. Most people just want to know, am I in or am I out? All right, so that answers it. If you modify the boundaries of the district in the future, you would have to bring that forward as a zoning amendment and replace the map that is in here. But our experience has been that is a small price to pay, because most people who are looking at a zoning ordinance just want to know which rules apply. And this is a very simple way to tell them, okay, these rules apply in your area, or they don't apply where your property is. SR, scenic roadway, you only have one, the Rock Quarry Road. It's remained unchanged. Historic preservation has remained unchanged. Floodplains has remained unchanged. We've labeled them all with O afterwards so that the reader knows they're all overlay districts. That's all. You now have overlays for communication antennas and towers and wind energy conservation system, or conversion systems, windmills. Those are just uses of land, and we're not used to seeing them as overlay districts, so they are now moved into the next chapter, which is uses of land and where can you do them. So they are not overlay districts in our draft proposal. Let's move on to permitted uses and get through that so we can open it up for questions. There were three things we were trying to do. One is that to consolidate this into one table, I've made this pitch 2 or 3 times, so that you can tell in this one chapter what you can do with your property, period, and you can compare it across districts. That helps you be more rational in the future. Even now, I'm hoping people read this and say, wow, it doesn't make any sense that we allow it here and here, we don't allow it there. What's the reasoning there? In the course of doing that, so we were trying to consolidate them into simpler, more flexible categories. We were trying to introduce new uses that Columbia Imagine says you want in your city that are not in the code today. And then the right-hand column over here means in many cases you can allow a use. You don't have to go to a hearing and you don't have to prohibit it, because as long as you subject it to certain standards to protect the neighbors, or hours of operation, or buffering, or a maximum size. And so wherever possible, we've tried to simplify it by saying it is a use, it's fine in this district as long as the following standards apply, and they apply automatically to this use. You don't have to negotiate them each time. Here is a use table. I think we've explained it before, but I know we have. The left-hand column, these are just snippets of it. It's not the whole table. The whole table is in the draft that's posted. The left-hand column lists in different categories what the uses are. So guest accommodations is a category, and underneath it, bed and breakfast, hotel, travel trailer park are the uses. Office is a category, and then there are different things underneath it. The columns after that, in various shades of gray, are each zone district in our recommended menu of zone districts in Columbia. If you'll notice in it, there's a line missing there, but for example, look at the residential columns. The lower half tells you what it's called today, the upper half tells you the new name. So you can look at this both from the point of view of the recommended consolidations, or refer back to the names you're used to calling them today, at least for this point in the process. The right-hand column gives you the any special conditions that apply, and I'll walk you through what those are. The next to last column simply says, if you are a planned development, you're now called PD, and what are your uses? Well, your uses are the ones you negotiated when you got approved by council. We're not listing them. We're reminding the lay reader, if you're asking a question about the PD district, you're not going to find the answer here. You're going to have to go to the Community Development Office and look at that PD, which is the case today, really. So we identify all the uses. Everything's categorized as either a permitted use, a conditional use, meaning you need permission, accessory use, which is fine as long as you're doing an allowed primary use on the property, but it's not allowed all by itself, a conditional accessory use, or a temporary use. So there are 5 denominators. The categories are more broad and flexible. I want to point out office as an example. Office, if you could read that on the screen, says office, and there's a footnote 229. That means there's footnote 229 right below it. There are over 300 footnotes in this draft, and there'll be more when we get the rest ones out. The footnotes identify what changed. In this case, it says office includes what you used to call this, 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 and this. So if you're wondering where your use is it allowed? Is it still allowed where I want it to be allowed? You read the footnotes, you go look for that term, and the footnotes will find it and say that's now called office. So that's how you find it. There are many footnotes down there. If we changed it, we footnoted it. I'll call your attention to something else, but office is a good example of consolidation. You'll see a green P there. Every slide I'm showing you shows some different rows of the table, and all of them have green levers. Green means an area where this use is now allowed more easily than it was before. Either it wasn't allowed before and we now say it's fine, subject to the conditions in the right-hand column, or it was a conditional use now and we say it is a permitted use today, or it wasn't allowed and we now say it's a conditional use. But life got easier if you're promoting this use in some way. This, in a broad strokes, this is the way modern development codes go. Lighten up on your regulation of uses, put conditions that are automatic on them in the right-hand column if you need to, and then focus more on the site layout, which you'll see in October. So this is in the kind of moving towards the mainstream approach towards uses in development codes. And then we've talked about these use-specific standards. Well, what are they? Here you'll see that they go V, W, X, Y, Z. Here is an example of what they are. For example, I'll just read one. The top one is commercial or trade school, and it says, in the mixed-use office district, this use is not permitted to offer retail sale goods or services to the public. There's no footnote on there, which means we didn't change it. That's in your code now. What we did was rename the current OP, O1 and O2 to mixed-use office, because that's the new name. But these are examples, and then office is down below. I'm sorry, that was commercial or trade school is a new name. But offices has three categories. We have research and development factory that says you can't do dangerous chemicals in some of the zone districts. Personal services is another category where we've combined many uses into one, and it has a footnote. So if you read that footnote, 296, you will see, we will explain what changed here. What do you get to do or not get to do now that you could before? But the footnotes are very essential, and for those lawyers and zoning geeks in the room who want to know, Don, what changed? You read the footnotes. That's what they're there for. That's how you find out what changed. So look at your column, look at the uses that you care about, figure out what changed. This is only an example, but I wanted to make it for three purposes. A, we footnoted the changes. B, many of the conditions that are in the right-hand column only apply in some zone districts and not in others. So the fact that you want to do something and it has a letter in the right-hand column, you go read it, it may be a very short read. You look at it, but I'm not in the mixed-use office district. This has nothing to do with me. On the other hand, some of you who are very engaged in this process may look at, I'm just making this up, like a commercial and trade school and say, wow, that's a good idea. That should apply beyond that. It shouldn't just be in the MF district. So I urge you to look at these use-specific standards. The point is to build into the rules the things, not only to carry over what you have now, but to build in the conditions that would make it okay to have this use in this district. I'm not going to go into as much detail as I have in the district, in the businesses. I will call your attention to the fact that the state of Missouri recently revised its regulations of sexually oriented businesses, SOBs. In the terminology we use in this code, those are adult businesses. There are two kinds, adult retail and adult entertainment. They're listed separately because adult retail, the selling of books and videos and cakes and clothing, has less impacts on the surrounding area in terms of drunkenness, litter, crime, etc., than adult business bars do. I'm sorry, I don't hope to offend any bar owners. If you're a strip joint owner, I apologize to you, but you can only regulate adult uses. Most cities wish they could just not have them, frankly, but you can't. It's free speech. You have to regulate them based on their impacts on the surroundings. And there are lots of national studies as to what impacts happen. Those studies tend to show that the biggest impacts are around adult entertainment, bars and theaters and strip joints. If you're selling books, you may not like it. You may sell cakes. I don't particularly like that stuff either. But the studies seem to show there's no more littering, there's no more drunkenness, there's no more drunk driving, there's no more crime around those than anywhere else in the. So they're treated differently in the code. And the thrust is that's the rationale. The standards, if you go over to the right-hand column on adult uses and say, well, what does BB say? BB says what the state of Missouri's new standards on adult business. We have been asked by staff to align the city with those new state approaches. You can look at them. There's no reason you have to. You got some home rule powers, but the draft in front of you aligns you with the new state law in that area. There are some additional heavy vehicle sales restrictions on outdoor uses I'd call your attention to. I want to use this slide just to point out that we've added some new things that Columbia Imagine wanted. Farmers markets were not addressed in your current ordinance, but they are now. We have added a line, and every cell on that line is green. It's new. It wasn't there before, so it is a new thing that is being allowed explicitly. And in this case, in the right-hand column, there are no standards. We haven't put any standards in. I've got them. I've drafted for other cities. If you're worried about the impacts of farmers markets, we can talk about that. But in general, they tend to be pretty innocuous uses. The next one I'd call your attention to is urban agriculture. This is kind of like community gardens. I want to be clear about what we're talking about here. On the small scale, if you're growing stuff in your backyard, you're growing tomatoes and carrots and whatever you want to grow, that's always been allowed, but it wasn't explicit. Now it's listed. Grow them on your rooftop, it's okay. Grow them in your backyard, grow them on your patio, it's fine. It's listed. It just goes along with living in a house or a duplex. That's fine. On the other end of the spectrum, you've got some ag lands and you've got a farm with tractors and chemicals and stuff like that. That's fine. This is the middle. This is a community garden type thing. The thing that makes it, you need to address it, is this. It's a primary use of land. It's not a backyard garden. It's a piece of land that a community group or a property owner wants to use to grow things in an urban area, and there's no house on it. This is not accessory to anything else going on the land. This is what's going on the land. It is the growing of stuff on a parcel of a couple of acres. Usually the maximum you get is a city block. Usually it's less than a city block. And the question is, I'm a property owner. Property's lied vacant. I'd someday like to develop it for housing. But in the meantime, I've been approached by a community group. Can we do a community garden as a primary use of land? This new addition says, yes, you can. And there are conditions. In this case, lots of questions come up. Can I sell the stuff I grow on the property? Can I have a shed? How tall the shed? How close to the property line? Can I have a cold frame? There are lots of questions that immediately come up. Everybody likes community gardens, but they don't like the impacts. And so that S on the right-hand column, if you read that, it's our proposed set of standards for how you allow this to happen without impacts on the neighbors that are unacceptable. So but those are examples of new things. Finally, I want to point out 2 or 3 things. ADU, your accessory dwelling unit ordinance, has been adopted by council. It has been rolled in here. We did recommend one change to it, and I'm going to spring another one on staff because it came up in our last meeting. The one change is that the current adopted ordinance, that council adopted ordinance, that limited them to external freestanding garages and accessory buildings. We recommend they be allowed within the structure, single-family structures, to attics over garages and things like that. So you can accept it or not, but we've been told in those cases where council is considering an action during the time we're drafting this, that we track what they're doing and we go ahead and recommend if we would have suggested something different than that. So in this case, we are recommending that ADUs be allowed a little more broadly than what council approved. I do want to say we discovered something this afternoon. These are complex documents. I will discover things all the way along that we missed. Most of the ordinances that are adopted require that one or the other unit be occupied by the owner of the property. That's not in your ordinance now. It is in almost every ordinance that we have seen adopted. Yes, it's hard to enforce, but it tends to make for good neighbors because you know that the whole thing is not 2 rental units. The owner, if you ring the doorbell on the garage or the doorbell on the house, one of the 2 will get you to the property owner and you can talk about the party last night. That's different than a 2 rental property. So I'm serious. Most codes say that. I know you considered it. I don't know how the debate went. I know you didn't include it. It's our opinion that that's something that we ought to include. And it's not in the draft, but I'm making that comment to myself because I missed it. So there we are. We have a category called customary accessory structures. This is a small building or a support structure or support use that is supporting your primary business or residential. No matter how hard we try, we can't list all these things. There are more of them than anybody could list. So you need a catch-all. And the definition of a customary accessory use describes what I just said verbally, but it also says this does not include the others that are listed. It doesn't include an accessory dwelling unit, it doesn't include communications antenna, it doesn't include a drive-up facility. If we listed it separately, then it's not included in the catch-all. If it doesn't fall into one of these things that we've regulated separately, then you go to the definition, is this customary and subordinate? Is this something that you usually see in combination with that use? If so, you can see there are A's all the way across. It's allowed. We've tried to tighten up the definition, but that's the way it's treated. And then, as I said earlier, wind energy, windmills, and cell towers are now included. We haven't changed the substance. We have just moved them from a district into the code, saying, look, the rules always said that these were the rules on wind towers and cell towers. The same rules apply. Instead of saying yes, no, your chapter doesn't say that. It says, here are the standards for where they can happen, and we just cross-reference that chapter. And then we've added some we've tried to distinguish primary uses from accessory uses from temporary uses, and seasonal sales is an example of a temporary use that we have added and footnoted the changes from what you have now. As always, I talk very fast. I don't apologize. It's just who I am. But I did get through it. I wanted to get through it so that those of you who just wanted an update could get an update, and we're now open for whatever questions you'd want. And then we can talk about next steps, or do you want me to do that now?
If anyone has any questions, I'll pass the microphone to you. The reason a portable microphone is we are recording, so keep that in mind.
Yeah.
Get you a second. Get this fellow.
Yeah, I'm Phil Warnken. I was interested in your comments about, is this on?
Yes?
Okay. I was interested in your comments that you met with neighborhood associations
Yes.
at some time recently.
Yes.
And is the assumption that those neighborhood associations in fact represent the neighborhood?
Well, we know that they don't represent everybody in the neighborhood, and we'd be happy to have comments from anybody in those neighborhoods. That's why we have the public meetings.
Is your assumption that they represent the majority in the neighborhood?
I'm not going to answer that question. We will take comments from any citizen in any of the neighborhoods that wants to comment, and we know from our discussions with the different neighborhood groups that they have significant people in their neighborhoods who don't agree with them. They've made it clear.
And how can we get an invitation to those sessions?
Okay. Well, generally, in terms of the general public, we do through these public meetings, but if
I'm
you...
talking about the neighborhoods.
Oh, to get invited to those meetings? Oh, Tim, invite them next time. That's fine.
Just express your interest
Okay.
to us, and we'll put you together.
They're not intended to be exclusive. We have made it clear that when we come back on these visits, we're happy to meet with whoever wants to meet with us on this and get feedback. Yes.
Well, I had three quick things, but one of them is on this. So in this process, did you meet with the Columbia Apartment Association?
We had a representative in the meeting. Yep.
And that isn't, I mean, doesn't take care of everybody. That is but one of the key representatives
Yes.
of that group. Well, I had two questions, and I'll ask them both, and then you can answer them as usual.
Okay.
One of them is, what is the difference between a zoning district and land uses? Now, I know in some things that a local attorney has outlined, it's sort of like, well, land uses are very general and those and the council has ultimate discretion in those things. Zoning districts have almost as much, but it's down kind of down below that. And so on a hierarchy of discretion. So in the system you're using, what could you distinguish those two?
Well,
and then the other question
Okay.
is, I like the idea of consolidating the planned districts. So on the assumption we can work through and get to the place where the standards are the standards, that's the standards that go with the permitted uses,
Yes.
and really those are pretty rock solid. What then would be left that would be a typical one or two situations for which a planned district would now really serve a useful purpose? Those are my
Yeah.
questions.
Okay. Let me answer the second one because it's easier. Planned districts were intended to be used for either large kind of master planned communities where they're laying out an unusual pattern of housing or open space, and you can't get a configuration of the standard zone districts to work. So it is, or a very complicated, sometimes a very complicated small parcel, but it's very unusual. So they're intended to be used for exceptionally difficult or complex or large categories of land. And they were intended originally as not just a way to package variances, not just to do a wish list of everything I want to do and take it through council. They were intended to be trading flexibility for public benefits. And the ordinance generally says, we'll give you more flexibility if you give us something on that the public wants in greater amounts than you would have otherwise. It was supposed to be a trade-off between the two. So before I go further, I'll give you, I guess my example would be a really unusual mix of, let's say, housing types, where the city looks at it, the neighborhood looks at it, and they say, let's not an R1 or R2, but this is cool. We are getting a variety of housing types, maybe a diversity of people living in this area, but to do it through a combination of R1, R2, and MF would look like a checkerboard by the time we're done, and that's kind of micro-zoning. Let's adopt it as a planned district that allows you to mix them in this pattern, and we know that that may change over time, and you may need to change it. So that's just a partial example. In terms of your first question, the difference between land uses and zone districts, I'm not sure I understand, but I think I understand. Both of them really, when you're rewriting a code, are frankly up to the discretion of council as to what they want to adopt. So I put this slide up here to say, well, actually, let me get the next one up here if I can. What you may be asking is this. Here, this is a good example. In the fourth column from the right is an agricultural zone district. You have one before, you have one now, we haven't changed it. That's an ag zone district. But we also have this category of uses, agriculture and animal-related uses. And but you can see that there's not just one thing, there's several things in there. There's agriculture, there's farmer's market, there's greenhouse, there's pets, because it's animal-related, urban agriculture, and a veterinary hospital. We just grouped them into agriculture and animal stuff. It is not, if you can see that there are Ps and Cs in a lot of zone districts other than the ag zone district. So the ag zone district is designed to accommodate farming. But there are many types of agricultural uses that you may want to allow in other areas of the city. So we have a category of agricultural land. Industrial uses are the same way. Light industrial uses are sometimes not limited to an industrial zone district. But in terms of the discretion of council, the adoption of a new unified zoning ordinance or a unified development ordinance is a matter of discretion. They don't have to do anything. If they're persuaded it's better for the city, they have complete discretion to adopt the types of districts and the types of uses they want. And before somebody raises their hand, I'll say in the same boat, all of the uses and buildings that have been created so far are, if they become non-conforming, they stay as long as they want to stay. You're not wiping them out. I get a feeling some people are so enthused about Columbia Imagine, they'd like to have all the things that don't match Columbia Imagine go away. You can't make that happen. They just, nor is it good public policy. So, yes, you can adopt for the future anything you want, but in the stuff that exists is we're trying to protect it and allow it to continue.
Well, I'll follow up with, now I understand partly where my question came
Okay.
from. In Metro 2020, we had 4 or 5 categories called land use areas.
Oh.
Agricultural, employment
see.
zone, this
Yeah.
guy. And that may have been good, may have been, but that's part of where my question
Okay.
came from.
Yeah.
The other part was this discretion, and of course, in this discretion thing, the idea was the council has a lot of discretion to some on preliminary plats, and then in Missouri, very little on final. So
Right.
that was kind of
Okay.
that higher. So I think, really, my land use thing is just left over from
From comp
whatever
planning.
that meant, and I'm not sure it had a real conceptual meaning.
Right.
Hey,
Well, but it doesn't work on screens. Sorry, yeah. Sarah?
yeah, Don, you mentioned, Dan Cullimore,
Yeah.
715 Lion Street. You mentioned you've now included a use category for community gardens.
Yeah.
My belief is that those have been an unregulated use in the past. I know that the Community Garden Coalition has, at this point, 33 member gardens.
Wow.
Most of them are associated with schools. There are a number of group gardens and church-associated gardens. But many of the neighborhood gardens are on R3 or R2 property.
Okay.
How does this affect those gardens going forward, as you know, they haven't been regulated in the past? So.
Well, the zoning ordinance operates prospectively, is the short answer to your question. We're trying to align the development rules in Columbia with the vision of the future, and so it really applies going forward. For example, you said some of them are in R2. You may want to comment that you want to make them, we want to add a C in R2 so that it's clear that it's okay to do community gardens in R2. That's fine. There is a clause in the draft ordinance that says, listen, if you were permitted, and I think you're saying it was unregulated, so it was permitted, and this ordinance says you need a conditional use permit to do that, you are deemed to have a conditional use permit. You don't have to go get one. And the way nonconformities work is, I guess I would say, the standards that apply, these standards apply new. They would not apply retroactively to the gardens that already exist. So.
I think my question, I had understood that, but I think my question was about what, how do we manage this going forward for new gardens? So thank you.
It is tricky, I've had a number of people tell me they want to, Don, nonconformities makes you comfortable, but it doesn't make me comfortable. I'd like to resolve as much of this as possible. I would too. But I've told every group we've talked with, I think the primary goal, we should separate two different questions. Number one, what should be the rules that govern development and redevelopment in Columbia going forward so that it achieves Columbia Imagined? That's the primary question. It's not worth dumbing that down and diluting it because of what's already been built. If you're worried about what's already happened and the investments in businesses or structures or things that have already happened, we should be talking very carefully in Module 3 about how to make sure that the nonconformities are protected, that past investments are protected. I'm all for that. I know some neighborhoods may not be. I think once you've allowed things to be built in a city, they exist. You got to allow them to be used and reused, and they've already been built. That's fine. But that's a different question. I really react badly when people saying, we have to allow this use that we don't want in this district because we have in the past. No, you don't. You need to protect the guy that did it in the past, and then you have to have the code reflect where you want to go in the future. And those are two different issues that require two different solutions. So, yeah. I'm sorry.
I'm Bonnie Myers,
Sorry.
and I have a question about innovation districts, if you're familiar with that term.
We are.
They popped up just within the last couple years, and they're here to stay. Could you comment on, now we're a university town, and of course the university has a lot of innovation districts. I'm not talking about those per se.
Okay.
I'm talking about entrepreneurial activity. You could have a cluster for mobile phone apps or whatever. A lot of them are a combination of live, work, light industry, manufacturing. One example would be, say, the food industry. You could conceivably have, a community garden with retail. You might have new products and services being formed with the use of a commercial kitchen.
Yeah.
You have the maker economy, which says we're going to be more involved into physically making things and products. So all of these industry clusters, innovation districts, will be springing up throughout the city, hopefully. We want to see them all over. And as the workforce continues to change, traditional office space is going to go to the wayside. We're all going to be more focused, I think, into particular, what we call the new economy. Then I think of the art district. The typical art district is very unique and special in a way. So do you allow for innovation districts or innovation hubs, if you will?
Absolutely not. No, I'm kidding. No, we do. Here's how we've tried to address that. I think we have addressed that. We did not use the term innovation district, but I'm in complete agreement with you with where the economy's going. And there are two or three things we've done in here that I think get at that. Our our approach was not to name them and say you can do them here. Our approach was to say we want to encourage these to happen everywhere, in most places. And so one of the things we did was there was a new category of housing, live-work housing, which doesn't exist now, which would allow you to live in and produce things in a district, in a house, a structure which is basically a townhouse-looking structure, but you can do the business in the ground floor, or the public can patronize your business. So that's kind of a living and working in the same place. That is a new use. Love to have comments as to whether we got the standards right or whether it's allowed in the right places. The second thing is we've added a new category of what's called artisan industry, which is many codes that allow people. If you were just making something in metalwork, we used to say that's industrial, doesn't belong in the downtown area. We've tried to add and define artisan industry as craftspeople, either food or beverage or crafts and sculpture and art that are being made on the premises. Do they involve welding? Yes, they do. Does it involve a kiln? Yes, it does. But they're selling it out the front door, and it helps support the art community and the walkability and the diversity of downtown. So that's an example of where we've said, technically we would call that industry. We've called it artisan and allowed it in the commercial districts in addition to the industrial districts to allow people to, in small areas, make something and sell it from the same industry. So those are things, again, we haven't called it innovation, but we've tried to allow these mixes of making and selling and making and living in the same structures, which I think is responsive to what you're asking that we accommodate.
Just a follow-up question. I have two neighbors that sell things in their front yard. And as we get more into making things, people doing it out of their garages, the one neighbor sells plants and shrubs in his front yard in pots, fruits, vegetables, whatever. And I thought, this is getting a little tacky because they're all over his front yard.
Okay.
My other neighbor, who happens to be just a mile west of here on Broadway, sells cars in his driveway. And I would say the majority of the days in the week, he has either 1, 2, 3 cars with for sale signs on them. And he must do a very lucrative business because this has been ongoing since he moved into the house, which he built. And I think that's a little tacky. Do we have restrictions on selling whatever in your front yard?
Not in the. Well, I was so happy I had a good answer for you on the last one. Now I don't. I can answer them briefly. Let's answer the second one first. Selling things from the yard. The draft that is posted on the city's website says you can, if your kids grow or you grow tomatoes or plants on your property, you can't bring them in on a truck. But if you grew them, you can sell them. But it has to be limited to a 100 square foot place on your front yard. So there's a space limit that says, yeah, go ahead, but it's limited in size. And so that's a half an answer. Can they do it? Yes. Can they do it all over the front yard? Not under the new code. The second question about selling cars I have found to be almost insoluble because you can limit the number of cars, if you can get away with it politically, the number of cars that someone can park on their property. It's a terrible battle because somebody will show up with 7 kids with 7 cars, and it's hard to say you kids can't park their cars in your driveway. So you can do it. But in terms of the business of selling cars, I have not found it easy to do because if you tell them they can't be in the driveway, they put them on the street. And you really don't want to get into regulating. You can't have a for sale sign in the window. And so I'd be happy to have a discussion, but in general, it's come up in 2 or 3 of my prior projects. I have not found a good answer to that because I can't find one that is fair and could be easily enforced without the city being accused of being zoning Nazis. So, yeah.
Oh, just in relation to that last question, we do have restrictions on yard sales in the
Okay.
number.
That
It
you can
seems
have.
like it should be similar. It's sort of, in essence, a yard sale with cars.
Okay.
So
Well, we can, if you'd like, I can write it. The problem's not writing it. I can include that in yard sale and cover cars. The hard part is going to be enforcing it, I think. So,
I just had a bigger question. So will we run into any challenges or concerns about taking? Will there be any restrictions now in use
that
we're-
result in the city going to court?
Yeah, right, that.
Let me answer the question, then you've had your hand up. We'll go to you next. But the short answer is, in this process, I am sure somebody will say, Don, that's a taking. I'll see you in court. I have yet to wind up in court on any code I've ever written because of a taking. The question in a taking is not whether there's anything in the code that restricts you more than it did before. The question is, are you allowed a reasonable economic use of your property? And we always do that. As a matter of fact, I think almost every code we've drafted tries to allow more types of economic uses of property than it did before. So will it be said in the course of this process? Yes. Will you end up going to court on it? I would be astounded.
Thank you.
Thanks. I have to say that I have sort of the flip side of that, which is not a taking but a giving. And being a member of a neighborhood that's predominantly zone R3, what I see is that you're giving all of the R4 density to R3, which is already something that we're fighting. And I am hearing that you're saying, well, we're going to protect that by giving boundaries and so forth, but where do I find out about the boundaries? I mean, I'm seeing that we're giving everybody that has R3, giving them R4 designation, but where does the other stuff come in that shows some protection on that development?
It's a great question. It's a very fair question. The answer is in Module 2. There is a section of Module 2 which talks about how you taper down those densities and intensities to the neighborhood. So you're justified to be skeptical. It is just one of the unfortunate things that happen when you divide the work the way we did. However, having said that, let me say two things. Number one, those neighborhoods that have overlay districts or trying to get overlay districts, if you want to have an overlay provision that trumps this, the overlay districts in general do trump the underlying zoning. So there is an opportunity. I don't want to confuse the near downtown R3 zoning mixed in with R1 and 2, which I understand is a very real problem that we're trying to get at. That I don't want to bleed into a general citywide approach to R1, R2, R3. Those are two different things. So, A, you'll see it in Module 2, and you're entitled to withhold judgment for that. 2, you can get at it through the overlay districts. But 3, I would bet, based on some of the faces that are in the audience who are at the meeting today, we may be asked not to do that consolidation. This is one where Clarion raised it as something that we think could be done. But there's no drumbeat of the builders or the neighborhoods or others forcing that to happen, and Columbia Imagine didn't say it had to happen. So I expect to get some comments saying, Don, I know you're well-intentioned, but I don't like that approach. And the third answer is you could comment and we could decide not to do that consolidation.
Hi, Don. Thank
Hi.
you for being here tonight. And I know we're talking about land use and property issues. I'm sure you're familiar that Columbia has talked about gateways, north, south, east, west. And I'm wondering what consideration has been given to that as far as green space, if there are overlays for visually for these gateways into the community, because people that I talk with and myself feel this is a very important thing that we consider as we develop our community, how people enter into the community and how that appears.
Okay, good question. And we were aware that Columbia Imagine did raise that. It came up in our internal discussions. There are two ways you could do it. Or more than two ways, but the two obvious ways are you could map them. You could have an overlay district called Columbia Gateways and draw lines on a map and say within these areas. The two things that, there are three things that are usually controlled, but usually two. Most people in their gateway areas want more lush and intensive landscaping, and they want more restrictions on signs, because that's where the biggest signs happen. And second, after it looks like a commercial concrete corridor and I'd like it to look greener, the second comment is, it looks like a forest of signs, I'd like there to be lower signs. So signs and greenery are the two main things that people address in gateways. We could map it and have it as an overlay district and say, here are some alternative, or whatever you want to do. Some people don't want certain uses. I don't want car dealers on the entryways. You could do that. The second way, and the reason we haven't proposed an overlay, is that we want to try to address it in Module 2 in October by saying, here are the general landscaping standards that apply in Columbia for these types of properties and situations. And if you are near the following listed gateways or you're adjacent to that frontage, and we'd have to define it with a map or something, then the following additional requirements apply. So we think we can get at it in Module 2, but it may be that after we bring those things forward, the judgment of the group sounds more complicated. We'd rather have you create an overlay of some kind. So we haven't forgotten it. We think we can do it in Module 2. It may be that upon reflection, we come back and look at it this way. So. Yeah.
Yeah, my question is about a change in definition to a lodging house.
Okay.
The way I read it in the footnotes, it shows that it's changed to group home large. And then when you read down to group home large, and it shows where it's allowed and not allowed, then it shows group home small. But the difference in definition is only, over 8 or less than 8. Nothing signifies that one is for drug and alcohol offenders or one is not, and what's allowed in R1 and what's not allowed in R1.
Okay.
Does this change any of that?
Well, I don't want to speak from memory. Let me tell you what our approach was, and then.
I'm just saying, currently, it's lodging homes aren't allowed in R1,
right.
And this changes that definition. But the definition between group large and small is a little ambiguous, and it doesn't specify which one's allowed where.
It is an area of, well, Kristen, have we listed separately in the use table, don't we? Okay, group homes, small are allowed everywhere, and then?
large are restricted to our,
Okay.
and then.
So the answer to your question, I think I understand your real question. What changed? We changed the definition to try to align with the Federal Fair Housing Act amendments. So instead of trying to name particular groups, we've tried to make it, and that means the federal government requires that you make available. You don't make unavailable, meaning you make available group living situations for certain types of folks, physically and mentally handicapped, recovering AIDS patients, recovering alcoholics, not active drug users, but recovering alcoholics, not criminals, not transients, not battered women, whether you believe it or not. There are categories that are in federal law that the courts have interpreted. And what we tried to do was to say, we've tried to change the definition so that it doesn't extend beyond those groups. But if this is a group home for one of the groups that is protected by the Federal Fair Housing Act, then a small one is allowed, and that's the number 8 that you cited.
So you will allow drug and alcohol offense.
We'll allow recovery
houses in R1 zoning.
Well,
Currently, it's
yes.
not allowed.
That's the draft, and I assume you don't want that, and you'll comment that way.
I just want to know if there's no green P that signifies
There's no
change.
a drunk house. Excuse me for saying that. I don't know what you want to say. We have some in Denver where there are people who they're not in a program. They're just habitually drunk, and this is where they live. Those are not allowed. People in a treatment program who are recovering drug and alcohol addicts, you cannot make that unavailable. As a general practice, when you're challenged in court by a group home provider, they are going to say, you are making that unavailable in most of your city when you make it unavailable in R1. Therefore, you should have. Sometimes the cities win those cases, sometimes the cities lose those cases. But to be very clear with this group, yes. And if you wanted to change it to say, Don, federal government, who cares? We don't mind mental and physically handicapped, but in R1, we want to say no recovering drug and alcohol addicts. We would draft it that way. That's fine with me. I want to point out that we're trying to align ourselves.
Right now, as it sits,
that's right.
It would be okay for 8 drug and alcohol.
Recovering drug and alcohol in a recovery. That's right.
Okay.
That's right. I expect there'd be a lot of discussion about that. Yeah. Well, let's talk about it a little bit more, because it's really important to have. This is an important discussion to have. It is not required that you do what the federal government wants. You just got to be willing to take a lawsuit from Oxford House when it comes in the door, and they're pretty good at suing people. Yeah. I understand. Yeah. I understand. That's right. That's right. Well, this can't fix that, but it is not. It doesn't deal with sex offenders. It deals with the protected classes in the federal. But you are correct.
I'm just saying that sex offenders currently live in
I understand.
and they're not protected by the fair
That is exactly right.
housing, so that's a violation.
No, it's not a violation. You can allow them anywhere, but you,
It says they don't have those disability protections.
that's right.
As a disability home.
There is no law in the federal government that says you must allow sex offenders to live anywhere. The federal law is silent on sex offenders. That's right. That's right. That is not a he's correct. That is not a class of disability. Being a sex offender has been determined not to be. You can't say I have to live here because I'm disabled and the Federal Fair Housing Act says I have to live here. That doesn't apply. That's right. Well, the fact that they don't apply means that the city doesn't have to let you live there. The city can let you live there. It's up to the city whether they allow it or not. They don't have to allow it. They don't have, unless your state has a scheme. In Colorado, we have a statewide scheme, and the cities have all tried to say, oh, not in our neighborhoods, and the state Supreme Court has said, it's a statewide scheme. You can't mess with it. You can't. But I don't know Missouri law. But let's go on. I want to be clear, though. Let's pursue it just a little bit further. Your question was the unrelated individuals living together would have to change. Well, under Fair Housing Act, if you said, for example, 8's too many, let's say 4. First of all, you'd probably be vulnerable to a lawsuit because somebody's going to find somebody with 6 kids living in those neighborhoods or 6 people in a house, and they're saying, why do you allow husband, wife, and 4 kids, but you only allow 4 people in a group home? That doesn't make sense. You can't. Why would you do that? So you run 6 to 8 is what they're used to seeing because it's rare to find a family of more than 8. 6 to 8 makes the court feel like you're allowing people to live in about the same numbers as they might live in a house in this neighborhood. But if you did restrict it further, there's another trump card, which is that Oxford, I'm just using Oxford House as an example. The group home operator could come in and say, wait, you've only limited it to 6. I need 8 to make this an operating thing. And you, by the way, have some households in here with 8 people in them. They would make a request to the city for reasonable accommodation. You don't have to approve it. That doesn't mean you have to provide them a reasonable house. It means you have to be reasonably accommodating by bending rules that you can bend without hurting your whole land use scheme. And if you don't, you might be upheld by the courts, but most cities do. So my point is, yes, you have limits on how many unoccupied people can occupy a place. As a practical matter, if the effect of that is to prevent a group home of a reasonable family size in an R1 neighborhood that's protected by the Federal Fair Housing Act, they're going to ask you to bend on that rule and allow that number of people in there. You don't have to approve it. You just have to be willing to take a lawsuit that says you did not reasonably accommodate me. You didn't give a good reason why I can't have 8, even though you said it was 6. And you say, oh, we're defending a citywide scheme. Well, the courts are not going to take that. They're going to say the federal government intended for you to be more flexible in this situation than otherwise we think you're being unreasonable. So I'm sorry, I can tell the stunned looks. Nobody likes this. It's one more reason to hate the federal government, but I don't make the rules. I just deliver them. So. But this gentleman raised a good point, and the recovery facilities is something I think you should comment on if you feel about it.
Don, I'm Nick Peckham. I'm chair of the Infrastructure Committee of the Downtown Leadership Council. One of the challenges that we have here in Columbia is that there's a disconnect between what's permitted in zoning and what's possible on the ground. Is there any way your work can help address that?
You mean that is permitted by zoning but impossible to serve with utilities, electric
Correct.
and water and sewer on the ground?
And other utilities, right?
Yep. The straight answer is yes, zoning ordinances can address that. We were not asked to address that when we bid on this job, but you can. I've had conversations with others in the crowd about it. There are cities and counties that adopt adequate public facilities regulations that say, here's what you're allowed to do, provided we have adequate services to serve it. Until the day we get adequate services to do it, you're not allowed to do it. So it could be done. I want to be clear that I don't want to wade into a second issue. We're going to be tough enough to get the UDO, so I'm not inviting myself into that. But you ask if it could be done, yeah. Communities sometimes do that. They have to do a study, and I think you have done studies about some of the infrastructure inadequacies downtown. You have to be able to have a reason. As a general zoning matter, as a matter of general land use law, City Council uses zoning to protect the public health, safety, and welfare. If you deem it that it is not protecting the public health, safety, and welfare to allow buildings to be built that you can't serve with sewer, the courts will uphold you on that. You don't have to approve things that you cannot serve. It's just not true. You don't have to do it. So they can be linked, but it's a pretty complicated field.
I have a second question. One of the tools of urban design, as you well know, is a build-out diagram of what the present or future zoning may permit, so that you have a three-dimensional model of the city. And the contemporary practice is to have this linked to a GIS model that has all sorts of data tied to what would be a three-dimensional representation of what may happen. Are you making a recommendation one way or the other on that?
We have not been asked to make a recommendation on that. I think it's inevitable that, well, we do recommend you put your Unified Development Code on the web in a highly searchable form where you can find your property and find which rules apply to your property on the web easily. That is tying GIS usually to zoning. That takes some work to do. You're asking about three-dimensional modeling and having a visual representation for my lot or your lot as to the envelope of what could happen there. I think it's a neat tool. I don't think it's normal yet. There are a few places that have done it, and I haven't been asked to make a I think it's cool, but it takes a lot of money, and I can't tell you that most cities Columbia size go down that road.
Thank you.
Well, I guess I had a couple of follow-ups, one of which is I happened to meet some people today who rented a house for $2,000. They're 6 unrelated students. And they rented the house for $2,000. They did not rent 3 apartments, all that. So our rules about 4 unrelated people, actually, potentially, they're in violation of.
Well, they're in violation of your rule.
Right, okay. I mean, that was just, and I must admit, especially since I always found it unuseful to kind of, and a really bad idea, to force people to break up older houses into separate apartments and then go with the rental compliance. I mean, it's been a disaster in North Central over the years.
I know, they feel that way.
I must admit, hopefully there'll be another discussion separate from the group home issue about the unrelated stuff.
It's a different issue.
But that kind of thing has a lot of emotion, but it's also had very negative effects in North Central and basically a lot of places north of Broadway. The next thing I was going to ask about was, if I understand, if I characterized having the appropriate zoning as one of the conditions, the appropriate conditions for getting a building permit, an occupancy permit, and those other kind of things, not as a right to do it, but it's because it's for public health and safety. As you go through this process, so zoning is not a right to build, is what I'm saying. It is one of the preconditions that is constitutional as part of regime that needs to be met. It's not the only. And so when Nick is talking about adequacy of public resources requirements, I've asked you about this and so forth, those are possibly other appropriate preconditions that cities about.
I think those
So my last thing had to do, I was very interested in the live-work, a big deal in North Central West. I mean, we've been, 45 years ago, we were 60, 70% owner-occupied. Now we're 75, 80% absentee landlord. And a lot of that had to do with the difficulty of people who might have owned their homes if they could have conducted a small business or something there.
Right.
And Columbia's had in its home-based business rules as conditional uses in different in R1, R2, and R3 has been just viciously opposed. Well, that meant going to get loans. It was just one of the vectors that helped drive us to this kind of stuff. When you proposed the new live-work, were you kind of working away from the home-based business rules you saw we had? Were you just thinking about what some other people were doing? Because in general, what I see is the idea is moving to something in which there is a use by right, subject to the permitted, the standards that attach to that, and maybe with some special conditions. One, is that kind of where you came from? And two, as I remember, because I tried to get one of these things enforced, generally in a home-based business rules, I mean, the problem, you could not use too much of the property.
Yeah, there's a limit to how much.
It couldn't have all kinds of trash around. It was about how many employees and how much traffic and parking and how much traffic. And I must admit, are those part of kind of the standards in the live-work things that you're proposing? The things that I thought were kind of reasonable for the home-based business conditional use stuff.
Well, let me answer it this way. The way to think of home, the way to think of live-work is not that you can take your current house and say, I'm in this zone district, oh, I can run a full-fledged business. The home-based business stuff is out the rules because I am now hereby, I'm waking up in the morning and declaring that I'm not a house with a home-based business. I am a live-work. You can't do that. It's a type of structure designed with a living area and a production area that would apply prospectively if the draft goes forward. This is a product that you could build in this neighborhood according to these standards. It is not something that goes back and says, well, everybody can now run a big business out of the houses. But your second question, should there be good neighbor type of standards that go along with this? The answer is yes, and we've put some in there. They're generally less stringent than home occupations, because home occupations are embedded in a bunch of other homes. This is a housing product, a type of structure where most of your neighbors are going to be your people who are doing similar things to you. They're also bought in a live-work structure. So I want to be clear, when you think about it, it's not a free-for-all. It's a new type of thing that can be built. If you don't think it belongs, and it may well be, maybe that you look at it and say, it seems like a cool thing, just doesn't belong where Don put it, well, then tell me what districts you'd like to have it put in, we'll move it to those districts.
This is very much more like what Bonnie was asking.
It's what she said, yeah. But you need to accommodate, but I tell you, if I was in one of these nearby downtown neighborhoods, nothing would scare me more than the fact that we have home-based businesses. There's been criticism that they're not enforced as well as they should be. And now Don Elliott says, have at it. You know, in the interest of the new economy, everybody's house has become a business location, or every town. Oof, I'll die on that hillside.
So for those of us, because this is perspective, one of the things we didn't get done in some planning processes was to use an overlay to ease up on the home-based business rules in North Central. Frankly, to change the economic vectors for people in their houses. What it turns out is we still have that work to do. Because this is perspective, it's for a different kind of thing. Some of the ideas about this might be applicable, but for going back, that's work to be done separately from this.
That's right.
That's basically.
That's right. Sorry.
If I may, can I suggest that we wrap up the formal presentation with a few words from Don about next steps, and then anybody who didn't get a chance to ask their question will follow with that. And we have the room for a few minutes past 8, but I did say we'd end the formal presentation at 8 o'clock.
This is going to be easy.
You want to tell us?
Well, Tim, you may want to weigh in on this. The only thing left to do is to say, thanks for coming. Bear with us. We realize it's frustrating to not see the whole picture at once. Trust me, it would be just as difficult if I tried to explain the whole code. It really would be. So you got to bear with us on this. Please stay engaged. Please, I won't get down on my knees, but I will beg you, read it. Please read it. Consider this public service. It's worth some hours to do. I hope to get hundreds of comments, and then we'll figure out what to do. It's when you get through the process, when you read it, and I get a lot of comments, I'm confident we're on the right track. When I don't get comments, I'm scared. But let's look at the next thing. Module 2, again, we're going to try to summarize what we've got, and I want to be clear, and then we're going to put out a public, Module 2 is form and development standards. All the things we've heard about that so far, including the downtown. It's going to come out in October, and we're going to release it in October. Module 3 will be in January. The same thing. When we say feedback, we mean all the comments we had in initial conversations or that we've gotten. Whenever we come here, we meet with folks. And even today, some people had comments, and I had to say, good comment relates to Module 2. So I can't answer it today. I can roll it into our drafting. Good comment has to do with the process. I have to make notes of that and include it in Module 3. So that's where we're going. That is, I think, all we have to say. I do want to be crystal clear about this. There will not be a revised Module 1. It's a dead end to keep revising these things, because then new people will read it and I'll be asked to revise it again. We collect these comments. Kristen's been taking it. We've recorded this. We've got the notes. We are collecting it. We will move forward, and we have to keep the momentum of putting the other drafts out. And you may say to me, Don, did you fix Module 1 yet? I'd say, the thing you've asked about, yes, we're going to include it, but I'm not going to produce repeated drafts of these things. It's not how our contract goes, and we'd burn the budget, and it takes forever. So, but you will see the changes and the edits that we have had accepted in footnoted when we make those changes in the final version that we come out with in the spring of next year, so, or summer of next year. Yeah. Oh, I'm sorry, I should have said this. If I didn't,
Thank you.
did I say it before? Thank you. September 15th is the date we would love to have your comments by. Thank you, I forgot. Thanks. That's what Tim wanted me to say, September 15th. If you miss it, I mean, this is America, this is a democracy, you have an elected city government. We're not going to turn it away. However, our minds will have moved on to trying to work through the issues in modules 2 and 3. So it's easier for us to collect and you will wish you'd gotten it done because now you'll be trying to think through module 1 and also think through module 2. So September 15th is a way of kind of, the door is not closed, but we can put this and say it's largely, they got the feedback, we can move on to the next piece of this puzzle. So.
And we do have a central place for comments. It's my email address, tteddy@gocolumbiamo.com. Also, many of you are going to have questions that you need answered before you can complete your comments. So by all means, get those comments or get those questions to me as well. And if there are any I need Mr. Elliott's help on, we'll get an answer from Clarion and pass that on to you. But I think what you're saying is you won't be responding to each and every
That
comment
will not be responding to each
on a
and every one,
module-by-module basis. But the changes that appear in the overall draft will be footnoted. So you'll be able to see where comments were not only considered, but they led to some change in the draft.
We will footnote it and try to say, this has changed since the first draft you saw.
Yeah. And I want to mention where you can find Module 1 is the city website, gocolumbiamo.com. Go to the Community Development Department main webpage, and you will see Development Code Update, and there are new flags indicating it's new material. It's not only the Module 1, there's a summary of Module 1. I think it's a 3-page summary.
6-page, I think, yeah.
And then, yes, double-sided, it's 6 pages. Yeah. Then there's a summary table that shows the use category consolidation. So it shows left-hand column, here's all the uses we list in present code. Here's where they went in the Module 1 work. So you can kind of get a quick fix on those things. Other questions about the process?
You recorded this. I assume maybe you videotaped?
Yes.
Okay. So when, part of this is to stimulate these comments.
Yeah.
We could not get this process done with Metro 2020 10 years ago, and it became worthless. So this comment thing is really big. So, and I think having it on video. So when will that be up, and where will it be?
I can't tell you when. We will put it in the Development Code Update section on our webpage again.
You'll send out through your press releases and all this kind of stuff that it's up there.
Yes, we can do that, absolutely. Absolutely.
Because I'm
Yeah.
intending to use the fact that it's
Yeah.
up there, along with the other things, to nudge people.
Yeah. Is there a sign-up sheet in the back?
Good.
Now is the time.
It is the time.
If anybody wants to be added to our planning and zoning listserv too, this is part of the city's webmail, and that's another way to keep up to date with the project. We'll send you an email anytime there's a milestone activity. Give us your contact information on the sign-up sheet in the back. We'll be glad to add you to that or send you the link so you can add yourself to that webmail.
You had a question.
So you want written comments by September 15th?
Yes. Please send them to Tim Teddy. He forwards them on to us, but we got staff and us have got to have the same view of what the comments have been made. So thank you. People are getting tired. Thank you for coming very much. Hope you come back next time. We'll be back in a couple months. Thanks.
And Don and Kristen will stay for a little while to answer your questions. Thank you, everyone.